Good afternoon, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here in docket number 2021-153S. Present in the hearing room are Commissioners Belzer and Williams. Joining us virtually are Commissioners Williams, Curley Williams, Thomas, Powers, and Caston. We left off early this week with Mr. Rothschild. If you would take the stand, Mr. Rothschild.
Mr. Chairman, ORS has one preliminary matter.
Sure, go right ahead.
This afternoon, ORS filed, and if I can address it here at the podium, whichever you prefer, Mr. Chairman.
It doesn't matter to me, but okay. If you're going to stay there, if you would pull the microphone closer to you.
Okay. Well, thank you, Mr. Chairman and members of the commission. This afternoon, ORS filed a letter and a few attachments there related to the partial stipulation that was introduced in the record on Wednesday. When the stipulation was introduced, a question was asked about whether there were any documents or exhibits showing the operating experience and revenue requirement under the partial stipulation. And what the attachments to the letter are is there's attachments B, C, and D provide the operating experience, rate base, and rate of return under the three different ROEs that parties were recommended in this case. And then attachment A is a summary of the revenue requirements and rates under the three different ROEs. And we would ask that this be made an exhibit, a hearing exhibit, the letter and the four attachments.
Mr. Chairman, no objections to the exhibit. However, we would ask for the opportunity to file a responsive document if we feel so compelled. Mr. Huber was very kind to alert us as early as he could about the document, but it's still a short time frame.
Okay.
And Mr. Chairman, Roger Hall, Department of Consumer Affairs. I also say we do not object either, and I would just point out, as the commission is well aware, that while they show the three recommended ROEs, that certainly those aren't the only options for the commission to consider. That's all I would say. Thank you.
All right, thank you. Anyone else? All right, so this is the Office of Regulatory Staff's calculated revenue requirements. Palmetto Wastewater Reclamations, operating expenses, rate base and rate of return.
Mr. Chairman, if I can go through each one, if it would help.
Yeah, because I know all of these are submitted by different folks, but I don't think that they are identified. So attachment A is yours, right?
All four are prepared by ORS. Attachment A is really a summary that shows the revenue requirements under each of the three different ROEs. The parties have each recommended a different ROE, and also the rates that will result from using that ROE to calculate the revenue requirement.
Right. So attachment B is whose recommendation? The company's, right?
Yes, yes,
All
Mr.
right.
Chairman. And you'll at the top there it says ROE scenario 10.95%. So that's using the company's recommended ROE.
And attachment C?
Attachment C is using ORS's recommended ROE of 8.9%. And attachment D is using the DCA's ROE recommendation of 7.31%. And of course, as Mr. Hall noted, that these are using the recommended ROEs, but also there were ranges that the ROE witnesses provided, but these are using the recommended numbers that the witnesses provided.
All right, and I also think the consumer advocate noted that these are the recommendations, but it's the consumer advocate's position that the commission is not limited by these recommendations. Mr. Hall, is that correct?
Yes, sir, that is correct.
Okay. All right. So this will be marked as a composite exhibit and entered into the record as hearing exhibit number 8. Any other questions?
No, thank you. No, Mr. Chairman, that concludes the preliminary matter we had.
Mr. Chairman, may I ask a question?
Yes, ma'am. Vice Chair Belzer.
Mr. Huber, thank you and ORS for presenting this. I think y'all responded to a question I had the other day. But just so the record is clear, the attachment B, C, and D, those contain the stipulated accounting adjustments that were agreed to. Is that correct?
Yes, Madam Vice Chair. All of these are based on the stipulation. The only difference between the three is the ROE that's inputted into it.
Thank you very much.
All right. Mr. Rothschild?
Yes.
Mr. Rothschild, you are still under oath.
And Mr. Chairman, thank you. Before I begin, I think the chair is aware that Mr. Torini has been delayed at the state senate. He will be here as he can, but we're perfectly content for me to proceed without him.
Thank you.
Thank you. Mr. Rothschild, as I understand the ROE testimony, just generally speaking, each expert, and we've stipulated that you are an expert in the fair rate of return for a regulated utility, including its cost of debt, return on equity, and capital structure. But each expert will use his expertise to gather the relevant information necessary for him to render an opinion, in this case, on the return on equity. I don't mean to diminish what you do by abbreviating it, but it's Friday afternoon at 10 after 2, so I'm really just trying to establish that there's an exercise that's very complicated, I'm sure, and very weighty that you go through every time you prepare a report and prepare to testify in a rate case proceeding. Is that a fair summary?
I would say, as you said, I think it's a simplification, but in general, that there's a process of gathering information and doing the analysis, and then analyzing the analysis and making adjustment of what the analysis indicates.
And but further, as I understand it, for the process of determining return on equity, it is not necessary for the expert witness to go to the, in this case, wastewater facilities to review the facilities or to interview management or to make any assessment of the operations maintenance of the utility. Is that fair to say?
Yeah, I would say it's fair in general. We, as a rate of return experts, we focus usually on the capital markets, or is the main piece, and the knowledge that we have about calculating the cost of equity and investors' expectations is our focus.
And is it fair to say that as a part of rendering your opinion in this proceeding and the other proceedings where you've appeared here before this commission, you will make a careful and thorough review of other proceedings before the South Carolina Public Service Commission to determine what ROEs have been granted or capital structures have been awarded and the cost of capital that has been awarded for various utilities. Is that fair to say?
I really try to, I think I can add the most value is providing an independent analysis of capital markets. So although I'm certainly aware of some of the proceedings in South Carolina, particularly the ones I've been involved, but what I really try to focus on is saying, this is what capital markets are saying based on the models. And that's what I think the commission can use to make their decision.
All right, sir, thank you. And I know that you were a witness in the most recent Blue Granite case, and I know that you were a witness in the most recent Dominion Energy rate case. Have you appeared before this commission in other rate cases?
Also the PUI case as well.
PUI?
Yeah, Palmetto Utilities.
Yes, sir.
Inc.
Yes, sir. Good.
Yes.
Good. Now, I think that you take issue with Mr. Sorensen's testimony that if the commission accepts your recommended ROE, that it will put Palmetto in a distinct disadvantage in attracting capital. Is that fair to say?
Yes, in the context of my testimony in determining the market-based cost of equity, yes, you cannot just compare authorized returns of subsidiaries or authorized returns or accounting returns in general. It must be equated with the market price. So I think that to just compare the authorized returns for other subsidiaries is not a complete analysis, and I think you have to equate that to market prices to be able to make that assessment, and that's what I do in my testimony.
Very fine, thank you. And I'd like to try to understand your testimony a little better. Let me ask you this: you are aware that Mr. Sorensen is a licensed professional engineer in 4 states, including South Carolina, and has over 25 years experience in the water and wastewater industry, from heavy civil construction to design engineering and large facility project management to utility ownership and management. You understand that to be the case, don't you?
I do.
Yes, sir.
Yes.
And you did not dispute in your testimony that Mr. Sorensen was experienced and a capable manager of Palmetto Wastewater Reclamation, did you?
No, I certainly didn't do the research, but I do not dispute that.
And you understand that Mr. Sorensen's testimony was not that he was of an opinion as to the ideal or reasonable ROE, but rather that his opinion was that in his experience, your ROE of 7.31 was going to hinder him in attracting capital. You understood that was his testimony, didn't you?
It's when we're in the when it's in the context when he's saying directly that regarding what my cost of equity is and comparing that and saying that would put them at a distinct disadvantage. Immediately, my understanding is that's within the context of the purpose of regulation here, which is that the rate should be set based on the market-based cost of equity. So that's my understanding as him rebutting my testimony.
Now, you understand, do you not, that there are any of a number of water and wastewater utilities here in South Carolina competing for capital, don't you?
Sure. And
you understand from his testimony that not in addition to the states where Mr. Sorensen is president, South Carolina, Florida, and Alabama, the parent company of PWR operates in the states of Texas, Oregon, and California as well. You understand that from the testimony, don't you, sir?
Yes.
And I'd like to draw your attention, if I may, to Mr. Sorensen's direct testimony, where Mr. Sorensen testified, PWR has undertaken many projects with the goals of improving the system and its operation. These include projects to improve safety, both at the facility and in the community. For example, PWR worked with DHEC to change the disinfection process and moved from using gaseous chlorine for disinfection to using liquid chlorine, which greatly reduces the risk to the community in the event of an equipment malfunction. Do you recall that testimony?
Yes.
All right. But as I understand your testimony here just this afternoon, you would have no idea how Mr. Sorensen financed the construction of his chlorine facility, do you?
I have no idea how they specifically finance that project.
Yeah, that you don't, do you?
Well, I mean, generally in finance, we say funds are fungible. So an investor raises money and uses for different things. It's not. So I'm not sure I understand your question, but my answer is funds are fungible. I do not know, and I never have to go in and look specifically about how funds are used for specific projects.
So you don't know whether he had to take out a bank loan or borrow money from an affiliate or anything like that to fund it, do you, sir?
Not for that specific project. No.
No, sir. All right. Now, can we agree that Palmetto Wastewater Reclamation's current ROE of 9.93 would encourage investment in the utility? Can we agree to that?
And my testimony is that that is more than sufficient. That the market-based cost of equity should be lower.
Now, isn't it true that Mr. Sorensen's concern raised in his testimony was that not only was he competing with other utilities in South Carolina for funds, capital, but he had to compete among his affiliate companies at Southwest Water. He testified to that, didn't he?
He did.
And as a part of that testimony, he went to some lengths to carefully and precisely point out what returns on equity his affiliate companies were allowed to earn in other states, didn't he?
He explained what the authorized return, which would equate to a return on the original cost of the investment.
Exactly right. And so that's the reason why he pointed out, for instance, that the Texas affiliate, Monarch Utilities, has an authorized ROE of 9%, correct?
Yes.
And that's why he testified that the Oregon water utilities had an authorized ROE of 9.5%, correct?
Yes.
And that's why he testified that the PUI had an authorized return of 9.07%. Isn't that true?
Yes.
And so isn't it true that if the investor, whether an external investor or the investor within the Southwest Water family, has an opportunity to earn 7.31% on an investment here, or 9.50% on an investment in Butte, Oregon, the investor will gravitate towards the higher ROE of 9.5%, correct?
As I explained in my rebuttal testimony, investors would prefer a 30% return. Yeah, but that's not what we're doing here. We're trying to determine what do investors require. What is the cost of equity that investors demand, as evidenced by capital market data. So we can't say because investors would prefer a higher return, we should give it to them. If they authorized a 30% return in Texas, and investors would like that, but it doesn't mean they wouldn't invest in other states.
And isn't it true?
They'll invest in if it's equal to or greater than their required return that we can see from the analysis based on capital markets.
And thank you. And isn't it true that it is the law of the state that there are any of a number of factors this commission must consider in setting ROE?
Yes.
And your analysis would be simply one of a number of factors. Isn't that true, Mr. Rothschild?
Yes, that's my understanding. I want the commission to have an independent analysis that shows what capital markets are saying. That's my role.
And if Mr. Sorensen, a 25-year veteran of water and wastewater utility operations and management, expresses the view that 7.31 is just too low, his view may be considered by the Public Service Commission in setting the ROE. Isn't that true?
Yes, but at least from what I heard him talking about earlier this week, I don't know. I didn't get the feeling that he understood how to determine what a market-based cost of equity was. So I would certainly think they should take what he says into consideration, but I don't think he understood what the process involved and how the rates were set in that way. That was my understanding. So I would not say what he says shouldn't be considered. Of course it should. It seems like a real expert in terms of running a company, but in terms of equating it to a required cost of equity, I think he didn't quite make the connection.
Now, I think you were a witness for the Department of Consumer Affairs in the most recent Dominion rate case. Isn't that true?
That's correct.
And is it fair to say that your recommended ROE in the Dominion rate case was 8.63%?
That's correct.
And I'm not as good as Mr. Huber with basis points, but isn't that roughly about 130 basis points higher than your recommendation in this case?
That's correct.
Now, in fact, the commission granted Dominion a 9.5% ROE in that proceeding, didn't it?
Yes.
And you are aware that the Dominion order came down on August 16 of 2021, are you not?
Yes.
And
I
beg your pardon?
Yes, I was just trying. Yes, you said August 2021, right?
August 16, yeah, August. It was August 16 to be precise.
Yes.
And you would agree that the Dominion ROE award is the most recent award of an ROE by this commission. Would you not?
I certainly understand that was that decision came out in August 2021.
I'm sorry, you're not sure if it's the most recent one? I don't mean to put words in your mouth, of course.
I believe it is. I have not heard that there was a decision since then.
And the again, I'm looking at my friend Mr. Huber, who's more facile with figures than I am, but I think a 9.5% ROE would be 230 basis points higher than your recommendation in this case. Isn't that true?
That sounds correct.
I have no further questions, Mr. Chairman. Thank you.
All right. Are there commissioner questions for this witness? All right. Is there any redirect?
Yes, just briefly, Mr. Chairman. Mr. Rothschild, Mr. Elliott asked you about Mr. Sorensen's statements about the company potentially being disadvantaged with a lower ROE. Can you explain why that is not necessarily the case?
Well, it's important that we understand in terms of the Supreme Court decision, which says that rates should be set based on returns expected by investors for investments of corresponding risk. So when you just look at those authorized returns, as Mr. Sorensen does, he doesn't take the critical step, which is to look at what are investors demanding for those types of investments. And to do that, you need to look at market prices. So he doesn't do that. So when you just say that an authorized return in another state is a certain number, and we say that it can't be below that or the utility won't invest, I have to really emphasize that's just not true. That's a mischaracterization of a very important step, which is what our investors really need to return. And again, you have to look at the market prices of securities. And one important piece to recognize is that the authorized returns for water companies in the country are averaging in the 9s, but the investors, we can tell, love those returns. They're willing to pay 3.5 to 4 times the original cost of that investment to receive that return. In other words, their actual return in the market price is considerably less. So I think it's critical that the commission understand that you can't just make that comparison to other authorized returns and say, if the authorized return is lower here, they won't invest. Is just not true, because he's not giving the important piece, which is equating that to market prices of securities.
And I believe you testified before that the average overall stock market return that banks are telling our investors is maybe 5.5 to 7.5%. Is that right?
Yeah, that's correct. The average returns as published by JP Morgan, and then surveys that are done from most of the major pension funds and the firms that manage major pension funds, they're looking at returns in that range. I think it was 5.5 to 8.5%, looking at averaging in the low sevens in terms of expected returns, and that's for the overall market, which is for riskier securities than for regulated utility companies.
Thank you. And Mr. Elliott also asked about whether you look at other, what other commission decisions have been about ROEs. I believe you said you didn't think that was relevant. Why shouldn't the commission look at these other returns?
Well, that's a little bit of a delicate topic, because I certainly understand to some degree looking at other authorized returns, and I did bring that up in terms of some of the decisions in Illinois, which are 7.36 ROEs. The one the initial decision in Connecticut was around 7.79, and of course we know about Blue Granite of 7.46. So, but the main thing is we need, at the same point as said before, in order to equate investors' required return, we have to look at capital markets. So just to look at authorized returns it doesn't bring us to the market-based cost of equity, because we need to look at capital markets. Also, it's from the past. So if we keep moving forward and saying, well, authorized returns in the past were this, we have to do that again. Again, fundamentally, it's hard then to make sure that we have the most up-to-date cost of equity, which could decrease or increase. So we could put a company in a problem if the cost of equity is too low, because if the authorized returns are too low in the past, or if they're too high. So those are kind of the two reasons, just in summary. Is one, it's looking back, and we need to continue to look forward to make sure we update. And the other issue with looking at authorized returns is we're not equating or bringing the capital market data in there that allows us to look at and equate that to investors' expected returns on that investment.
Thank you. He also asked you about whether you are aware of how PWR raised money for some chlorine upgrades or changing chlorine. You recall that question?
Yes.
And I believe you said you weren't aware, correct?
No, I did not look at it.
Do you recall PWR's testimony that their capital comes from their parent company?
Yes.
And that would probably, in your experience, that would include the chlorine upgrade too, correct?
Yes, I would assume, yeah.
And then lastly, he was asking about the Dominion matter, and he pointed out that you recommended an 8.63, I believe, maybe 8.36, but somewhere around that number. The decision came out in August. Do you recall when you would have calculated that number?
Yes, that was during, I believe the date was up through September 2020 in that case. So that was during a very different time than today. That was when the uncertainties in the capital markets were still significantly higher than they were today. So that was really a significant reason why my recommendation was higher, was because of that. It's a very different time today.
And the point of your testimony is that you need to look at current market conditions, correct?
Yes.
And then lastly, I believe you pointed out that the authorized ROE in that matter was a 9.5, but you're aware that was part of a settlement agreement, correct?
Yes. Thank you for bringing that up. I was going to say that was my understanding, yes.
And you're aware that there were a lot of other conditions and things that Dominion was willing to do to relieve debt for those who had past due payments. They agreed to a long stay out provision. Does that sound familiar to you?
Yes, I recall going through that. Yes.
And so those would be some of the other factors Mr. Elliott mentioned for potentially why an ROE might be different.
Yes.
Okay. Thank you. That's all I have.
Thank you.
All right. Anything else for this witness? Yes, sir.
Mr. Rothschild, help me understand why the Department of Consumer Affairs and the Office of Regulatory Staff feel like the ROEs set as a part of a settlement don't count.
Mr. Chairman, I'd object to this. He's covered this. He's not part of the settlement discussions. It's something that comes between attorneys. And I believe it's beyond the scope of my redirect.
Well, Mr. Chairman, I've heard from Mr. Huber and now from Mr. Hall that when the ROE is set as a part of a settlement, it's irrelevant. It is as if it doesn't count. But, Mr. Chairman, in the Dominion case and in this case, this commission goes to great lengths to satisfy itself that all the terms of a settlement are just, reasonable, and in the public interest. And y'all went to great lengths in that Dominion case to prove every jot and tittle of that settlement, and it was lengthy, but you approved a 9.5% ROE, and it's as if counsel for the ORS and the Department of Consumer Affairs are suggesting that, that you gave no consideration to the public's interest and the ratepayers in setting that ROE. And so I'm asking this witness, and I'll ask Mr. Garrett, because he'll testify to the same, to explain why they think that your decision in the Dominion case, setting an ROE of 9.5%, the most recent ROE decision of this commission to this proceeding, it somehow does not count or shouldn't be taken into consideration. That's my position.
And Mr. Chairman, I would follow that up by saying, first, Mr. Elliott's the one that raised it, and second, this question that he asked, why Mr. Rothschild thinks the DCA and the ORS think something. I think that is completely inappropriate to ask beyond his expertise to get his opinion on what the DCA and the ORS think.
Objection overruled.
Thanks, sir. So isn't your understanding, Mr. Rothschild, that, that this commission in the Dominion rate case went to great lengths to analyze each and every provision in the settlement agreement, including the agreement as to return on equity? You understand that this commission went to those great lengths, don't you, sir?
Yes, I think it's just important to recognize that I recommended 8.63 as you brought up at that time, but the capital markets were very different at that time. Implied volatility was much higher. The uncertainty was just not really comparable. So I think in terms of what I can add here, and that is just the 8.63 to what I'm recommending is 7.31. Very different capital markets. I recently recommended 7.17 in an Eversource United Illuminating case in Connecticut. I think that's more reflective of current capital markets for a large electric company.
And no matter how hard you worked on your analysis and in preparing your report and preparing your testimony, the fact remains, doesn't it, sir, that this commission found a 9.5% ROE to be in the public interest in the Dominion rate case?
And the only thing I can do is to provide the commission with my independent analysis to what capital markets are indicating regarding investors' return expectations, and therefore what the cost of equity is.
Fair enough. Thank you. No further questions, Mr. Chairman.
All right. Mr. Rothschild, you may step down and you are excused.
Thank you.
Consumer Advocate, do you have any more witnesses?
No, Mr. Chairman, our other witness, Lafayette Morgan, was stipulated earlier. We will be getting a verification from him as soon as we can. I believe, do I need to cover his exhibits and or have they already been entered?
If you would, please, sir, move the testimony of Mr. Morgan into the record and the exhibits.
Certainly. Mr. Bear with me, just make sure I get everything correct. Mr. Morgan prepared 17 pages of direct testimony, which was filed on September 30th, 2021. That testimony, and 8 pages of surrebuttal testimony, which were filed on October 28th, 2021. So I would ask that they be moved, that testimony be moved into the record as if given orally from the stand.
Mr. Lafayette Morgan's direct, and surrebuttal testimony will be entered into the record or read into the record as if given orally from the stand.
Thank you. Mr. Morgan's direct testimony included attachments labeled Appendix A and Exhibits 1 through 10, totaling 126 pages. And would you like to put, as a hearing exhibit, his surrebuttal and direct exhibits together or separately, or does it matter?
You got a preference? Your preference, sir?
Okay, we'll do them separately. So I would ask that his direct testimony exhibits labeled Appendix A, Exhibits 1 through 10, be entered as the next hearing exhibit.
Witness Morgan's Appendix A, Exhibits 1 through 10 will be marked as a composite exhibit and entered into the record as hearing Exhibit 9.
Thank you. And his surrebuttal testimony included attachments labeled Schedule LKM1 through LKM13, totaling 16 pages. I would move to have those entered as the next hearing exhibit.
Morgan surrebuttal exhibits schedules, LKM 1 through 13 will be marked as a composite exhibit and entered into the record as hearing Exhibit 10.
Thank you. And with that would conclude his testimony. And again, we will get that verification filed as soon as we can.
All right. Thank you very much, sir.
Thank you.
Office of Regulatory Staff.
Mr. Chairman, might I inquire how late the commission plans to go? The reason I ask is our second witness, Mr. Hanel, has a conflict Monday morning. Well, I don't believe it's going to be an issue if there's lengthy cross of our first witness, David Garrett, or if the commission is planning on ending early, it may be prudent to call Mr. Hanel first.
Roger that. 5 o'clock.
5 o'clock. Thank you. Mr. Chairman, might I inquire the parties whether either has lengthy cross of Mr. Garrett?
Yes, you may.
I'm sorry, was he asking about cross for Mr. Garrett?
That's correct, Mr. Hall.
I do have some cross for Mr. Garrett.
And I've never cross-examined him, but I think my cross would be a little longer than the cross of Mr. Rothschild. We would have no objections to Mr. Hunnell testifying next.
Neither would I.
We will call Mr. Hanel first, if that's okay with the commission. If we change our order of witnesses.
That's fine with me, sir. Mr. Hunnell?
Mr. Chairman, if I may, I would like to go ahead and put in Ms. Seal's testimony since she's been stipulated in. Before we get started with Mr. Hanel, I can go ahead and do that.
Yes, sir, you may. Attorney Huber, if you would get closer to the microphone, please,
Sure.
sir.
As I stated, Ms. Christina Seal's testimony was stipulated as part of the partial stipulation. So this time I'd ask that her 19 pages of direct testimony that were filed September 30th, 2021, be made part of the record.
Ms. Seal's pre-filed direct and surrebuttal testimony will be marked and entered into the record, will be read into the record as if given orally from the stand.
And Ms. Seal also had 7 exhibits labeled CLS 1 through CLS 7. Those were filed September 30th, 2021. I would ask that those be made the next composite hearing exhibit.
Ms. Seal's exhibits CLS 1 through 7 will be marked as a composite exhibit and entered into the record as hearing exhibit number 11.
Ms. Seal filed 5 pages of surrebuttal testimony on October 28th, 2021, and I would ask if that testimony be read into the record as if given orally from the stand.
Ms. Seals, I think I've already entered or put her rebuttal testimony in, but we'll do it again just for good measure. Ms. Seals' rebuttal testimony will be read into the record as if given orally from the stand.
Thank you, Mr. Chairman.
And-
And also, Ms. Seal filed 7 exhibits with her cerebral testimony labeled cerebral exhibit CLS 1 through CLS 7. I would ask that those exhibits be made the next composite hearing exhibit.
Yes, sir. Ms. Seals' rebuttal exhibits, CLS 1 through 7, will be marked as a composite exhibit and entered into the record as hearing exhibit number 12. Is there
Thank you, Mr.
anything
Chairman.
else, sir? No? All right. Well, before this witness is sworn, we're going to be in recess for 10 minutes. Good afternoon, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here in docket number 2021-153S. Present in the hearing room are Commissioners Williams and Belzer. Joining us virtually are Commissioners Caston, Thomas, Powers, and Commissioner Carol Lee Williams. Commissioner Caston.
Can you see me okay, Chairman Williams?
Yes, sir. Commissioner Powers.
Yes, sir.
For some reason or another, your camera went offline. There we go. We have you back now. All right, Ms. Hare.
Thank you, Mr. Chairman, Madam Vice Chair, members of the Commission, Nicole Hare on behalf of ORS.
If you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You may need to get that mic a little closer.
Is this better?
Good afternoon, Mr. Hunnell. How are you?
Good afternoon. How are you?
I'm great, thank you. Could you please state your full name and business address for the record, please?
My name is Daniel Patrick Hunnell II. My business address is 1401 Main Street, Suite 900, Columbia, South Carolina, 29201.
Thank you. By whom are you employed and in what capacity?
I'm employed by the South Carolina Office of Regulatory Staff as a senior regulatory analyst.
Mr. Hunnell, I would like to briefly walk through your educational history and work background. Would you please tell the Commission any degrees that you have and in what areas you received those degrees?
I earned a Bachelor's of Business Operations from DeVry University.
And upon completing college and obtaining your degree, could you walk me through some of your professional history?
Absolutely. Upon completion of college, I worked for several years in the retail banking with PNC Bank. I then spent the next 20 years working on a variety of roles and for various subsidiaries of American Water. My most recent position at American Water was a principal regulatory analyst. In that position, I was charged with the preparation and development of both pro forma adjustments, as well as the overall pro forma revenue requirement for base rate cases. I was also charged with the preparation of alternative regulatory mechanisms along with other rate-related regulatory filings.
So would it be fair to say that you've got some experience in utility rate making?
In water and wastewater, yes.
Okay. And have you testified in connection with other water, wastewater rate cases previously, either before this commission or other state commissions?
I have testified before this commission on one occasion. I've also testified in Pennsylvania and West Virginia.
Okay, thank you. Mr. Chairman, at this time and consistent with the stipulation agreed to by all parties, ORS would proffer Mr. Hunnell as an expert in utility rate making and regulatory analysis.
Mr. Hunnell was qualified as an expert in utility rate making and regulatory analysis.
Thank you, Mr. Chairman. Mr. Hunnell, are you the same Daniel Hunnell who pre-filed 12 pages of direct testimony in this case on September 30th, 2021?
Yes, I am.
Do you have any changes or corrections to your pre-filed direct testimony?
I do not.
If I asked you the same questions today as those posed in your pre-filed direct testimony, would your answers be the same?
They would be.
Mr. Chairman, at this time, ORS requests that the pre-filed direct testimony of Daniel Hunnell be entered into the record as if given orally from the stand.
The pre-filed direct testimony of Mr. Hunnell will be read into the record as if given orally from the stand.
Thank you. Mr. Hunnell, did you also cause to be filed with your direct testimony 6 exhibits marked DPH 1 through DPH 6?
I did.
Do you have any changes, corrections, or edits to your exhibits?
I do not.
Mr. Chairman, ORS requests that Mr. Hunnell's exhibits DPH 1 through DPH 6 be marked as a composite exhibit and be admitted into the record as the next hearing exhibit.
Mr. Hunnell's direct exhibits DPH 1 through 6 will be marked and entered into the record as, are we on 13 or 14? She's saying 13. Is it 13 or 14? 13. It's fine. DPH direct, Mr. Hunnell's direct exhibits DPH 1 through 6 will be marked and entered as a composite exhibit, and that is hearing exhibit 13.
Mr. Hunnell, did you cause to be pre-filed 2 pages of surrebuttal testimony in this case on October 28th, 2021?
Yes, I did.
Do you have any changes or corrections to your pre-filed surrebuttal testimony?
I do not.
Mr. Chairman, ORS requests that the pre-filed surrebuttal testimony of Dan Hunnell be entered into the record of this case as if given orally from the stand.
The pre-filed surrebuttal testimony of Mr. Hunnell will be read into the record as if given orally from the stand.
Mr. Hunnell.
Mr. Chairman, Commissioner Thomas.
Yes, sir.
I'm having a little bit of trouble hearing this witness. If perhaps he could just get a little bit closer to the microphone, that might help.
Is that better?
Yes, sir. Thank you.
You're welcome.
Mr. Hunnell, did you also cause to be filed with your surrebuttal testimony 2 exhibits marked surrebuttal DPH1 and DPH2?
Yes, I did.
Do you have any changes, edits, or corrections to your surrebuttal exhibits?
I do not.
Mr. Chairman, ORS requests that Mr. Hunnell's surrebuttal exhibits DPH1 and DPH2 be marked as a composite hearing exhibit and admitted into the record as the next hearing exhibit.
Mr. Hunnell's surrebuttal exhibits DPH 1 through 2 will be marked as a composite exhibit and entered into the record as hearing exhibit 14.
Mr. Hunnell, did you prepare a summary of your pre-filed direct and surrebuttal testimony?
Yes, I did.
Please present your summary to the Commission.
Good afternoon, Mr. Chairman and members of the Commission. It's my pleasure to be here with you today. My direct and surrebuttal testimonies focused on ORS's review of the application of Palmetto Wastewater Reclamation Incorporated, which I will herein refer to as PWR, for an adjustment of rates and charges. Specifically, my testimonies focused on PWR's compliance with this Commission's rules and regulations, PWR's compliance with the South Carolina Department of Health and Environmental Control, or DHEC's rules and regulations, a brief overview of the acquisition of PWR by a subsidiary of Southwest Water Company, and an operational change that took place following the acquisition. The proposed rates that were required to produce the overall revenue requirement after ORS's recommended adjustments, and PWR's request to increase their tampering charge from a maximum of $250 to a maximum of $500. I appear before you today on behalf of ORS to request you approve the partial stipulation of the parties in this case, which was filed with you on November 10, 2021. The partial stipulation satisfactorily addresses all of the issues raised by ORS analysis of the company's filing, with the exception of the return on equity, or ROE. ORS continues to support ORS witness Garrett's proposed ROE of 8.9%. The ORS submits that the partial stipulation, taken as a whole, is a reasonable compromise in consideration of possible litigated outcomes before this Commission. ORS recognizes that the partial stipulation is a product of the balancing of compromises struck between the parties in this case. ORS submits that the partial stipulation is in the public interest as well as the best interest of PWR's ratepayers, and the Commission should approve the partial stipulation without modification. Regarding the partial stipulation and the impact to customer rates, utilizing the terms and conditions of the partial stipulation in the 8.9% ROE proposed by ORS witness Garrett, ORS calculates the monthly charge in the amount of $40.12 for the residential, commercial, and multifamily rate classes, and a monthly charge in the amount of $29.94 for the mobile home rate class is required to produce the overall revenue requirement in the amount of $3,907,055, which translates to a 5.81% rate increase. This concludes my summary.
Thank you, Mr. Hunnell. Mr. Chairman, at this time, Mr. Hunnell is available for Commissioner questions.
All right. So my understanding is that the party stipulated that there's no cross-examination of this witness. Is that still true?
That's correct, Mr. Chairman.
All right. So we're going to move to Commissioner questions. Vice Chair Belzer?
Thank you, Mr. Chairman. Good afternoon, Mr. Hunnell.
Good afternoon.
Mr. Hunnell, in looking at your direct exhibit DPH1, which was the business office compliance review, with regard to item 5, deposits charged within the limits established by regulation, you had a comment of no deposits charged. does the company not charge deposits or just none
No, it's
during?
my understanding the company does not collect deposits.
Okay, thank you. And then on your surrebuttal exhibit, which one is it? It's the first page. It's the calculated revenues. Those some of those, the calculated revenues seem off. When I multiply like residential 15,996 ERCs times 3,907, hang on, I get 624,964. I'm just curious.
Yes, ma'am. There is normally a little bit of remainder left over after you calculate the revenue requirement with the rates, and I just plug that into the residential.
Okay, they're all off just a little bit.
Yes, ma'am, they are.
Okay, thank you very much.
You're welcome.
Commissioner Caston?
No questions, Chairman William. Vice Chair Belcher took care of that. Thank you very much.
Okay, fellow commissioners, any questions for Mr. Hunnell? All right, sir, there appears to be no more questions for you. You may step down and you are excused.
Thank you.
Thank you, Mr. Chairman. ORS calls this next witness Mr. David Garrett.
Mr. Garrett,
Yes.
if you would take the stand and pause to be sworn in by our court reporter.
Mr. Garrett, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you, Mr. Garrett. Will you please state your full name and occupation?
My name is David Garrett. I am the managing member of Resolve Utility Consulting, a consulting firm specializing in utility regulatory analysis and expert witness testimony.
Would you please give a summary of your educational background and relevant experience, including your experience evaluating and testifying regarding cost of capital issues?
Yes, I have been practicing in the area of utility regulation for 10 years. I received a finance degree, a law degree, and an MBA from the University of Oklahoma. I worked at the Oklahoma Corporation Commission for 5 years, both as an attorney and an analyst before forming Resolve Utility Consulting, where I have represented a variety of clients in utility regulatory proceedings in numerous jurisdictions. I have focused my practice primarily in the areas of cost of capital and depreciation, and I've testified in over 60 cases on these issues.
Thank you, Mr. Garrett. At this time and pursuant to the stipulation between the parties, I'd request that Mr. Garrett be recognized as an expert in the fair rate of return for a regulated utility, including its cost of debt, return on equity, and capital structure, as well as customer financial protections known as ring fencing.
Mr. Garrett is qualified as an expert in the stated areas.
Are you Mr. Garrett? Thank you, Mr. Chairman. Mr. Garrett, are you the same David Garrett who pre-filed 84 pages of redacted and confidential direct testimony on September 30th, 2021?
Yes.
Do you have any changes or corrections to your pre-filed direct testimony?
No, I don't.
If I asked you the same questions today as those posed in your pre-filed direct testimony, would your answers be the same?
Yes.
Mr. Chairman, ORS requests that the redacted and confidential pre-filed direct testimony of Mr. Garrett be entered into the record of the case as if given orally from the stand, and that the confidential version remain under seal.
Mr. Garrett's
Mr.
pre-filed.
Chairman, may I ask a question?
Yes, you may.
Is, what's redacted is one particular thing in 3 different places as I read the testimony. Is that something that is confidential? I understand that when ORS gets materials from a utility, that those materials are to be granted confidential treatment by ORS, but is that something that is truly confidential?
Madam Vice Chair, I think the figure is the parent company cost of debt information, debt to equity information, and that would be confidential, at least with respect to these proceedings. The parent's not a regulated utility.
True, but, I mean, they decided how to do this. It just seemed a bit unnecessary, but that's fine. Thank you.
Yes, ma'am. Thank you.
Okay. The pre-filed direct testimony of Mr. Garrett will be entered into the record as given orally from the stand, with the confidential portions remaining under seal.
Thank you, Mr. Chairman. Mr. Garrett, did you also cause to be filed with both your redacted and confidential direct testimony 2 appendices labeled Appendix A and Appendix B and 17 exhibits marked DJG 1 through DJG 17 on September 30th, 2021?
Yes, I did.
Do you have any changes, edits, or corrections to those exhibits or appendices?
No.
Mr. Chairman, ORS requests that Mr. Garrett's 2 appendices labeled Appendix A and Appendix B and exhibits marked DJG 1 through DJG 17 be marked as a composite hearing exhibit and entered into the record as the next hearing exhibit.
Mr. Garrett's direct exhibits Appendix A through B, along with exhibits D, J, G 1 through 17, will be marked as a composite exhibit and entered into the record as hearing exhibit number 15.
Thank you, Mr. Chairman. Mr. Garrett, did you cause to be filed 15 pages of surrebuttal testimony in this case on October 28th, 2021?
Yes.
Do you have any changes or corrections to your pre-filed surrebuttal testimony?
No.
Mr. Chairman, ORS requests that the pre-filed surrebuttal testimony of David Garrett be entered into the record of the case as if given orally from the stand.
The pre-filed surrebuttal testimony of Mr. Garrett will be read into the record as if given orally from the stand.
Mr. Garrett, did you prepare a summary of your direct and surrebuttal testimony?
Yes, I did.
Would you please present your summary to the commission?
Sure. Good afternoon, Mr. Chairman and Commissioners. My name is David Garrett. I'm the managing member of Resolve Utility Consulting and have extensive professional experience in public utility regulation and specifically cost of capital analysis. I've been retained by the Office of Regulatory Staff to evaluate the cost of equity and debt capital in an appropriate capital structure for Palmetto Wastewater Reclamation, which I will refer to as PWR of the company. My direct testimony addresses the company's proposed authorized return on equity, or ROE, and capital structure in response to the direct testimony of company witness Paul Mall. My direct testimony also recommends various ring fencing provisions related to the acquisition of PWR's parent company, NE South Carolina Inc. by South Carolina Utility Systems Inc., a subsidiary of Southwest Water Company, which I will refer to as Southwest. My surrebuttal testimony responds to Mr. Mall's rebuttal testimony and addresses the ROE aspects of company witness Craig Sorensen's rebuttal testimony. Subsequent to filing my direct and surrebuttal testimonies, ORS and the parties have reached a partial settlement as to 3 of the issues covered in my testimony. It is my understanding these issues include a cost of debt of 3.79%, a capital structure consisting of 55% common equity and 45% long-term debt, and the ring fencing provisions included as part of my direct testimony. I do not object to these items included as part of the agreement and would respectfully request the Commission's approval of the same. I will now provide the Commission a summary of my direct and rebuttal testimonies. In my direct testimony, I analyze and make recommendations on the appropriate cost of equity and ROE, awarded ROE for PWR based on current market conditions, as well as the company's proposed capital structure and cost of debt. In his direct testimony, Mr. Mal provided an ROE analysis for PWR, ultimately recommending an ROE of 10.95%. He further proposed a capital structure consisting of nearly 60% equity and a cost of debt estimate of 3.79%. The Commission should reject Mr. Mal's proposed authorized ROE because it is excessive and unsupported. In addition to his use of forecasted growth factors, Mr. Mal employs the use of leverage adjustments that further inflate his ultimate ROE recommendation. By comparison, my objective cost of equity analysis shows that PWR's cost of equity is about 7.1%, which is within a range of 6.3% to 8.0%. The legal standards governing awarded ROEs do not mandate the awarded ROE equate to the result of a particular financial model, but rather that it be reasonable under the circumstances. In my opinion, it is not appropriate to use an awarded ROE significantly above a regulated utility's cost of equity. Accordingly, I recommend the Commission award PWR the opportunity to earn an ROE of 8.9%. Although 8.9% is still above PWR's market-based cost of equity estimate, it represents a gradual yet meaningful move toward the company's market-based cost of equity. My rebuttal testimony, in part, addresses Mr. Sorens's contention that my recommended ROE would put PWR at a distinct disadvantage in attracting the capital necessary to operate, maintain, and improve its system. It is my understanding that Mr. Sorensen is not an ROE expert and has not conducted a thorough analysis of the company's cost of equity. As I describe in my testimony, a company's performance record is not among the criteria used by cost of capital analysts in determining cost of equity. An objective cost of equity analysis should be based on recent financial and market conditions taken in the context of a reasonably selected group of proxy companies with similar risk profiles to that of the subject company. I would encourage the Commission to continue to preserve the Hope and Bluefield standards of primarily basing the utility's authorized ROE on its cost of equity. With respect to the company's proposed capital structure, I recommend the Commission reject PWR's proposed capital structure consisting of 40% debt and 60% equity. As for the cost of debt, I make no adjustment to the company's proposed 3.79% in my testimony. In addition to the cost of capital components, I also recommend the Commission consider adopting several standard financial protections known as ring fencing provisions to help insulate PWR's customers from any undue risk potentially resulting from the recent acquisition of PWR's parent company. This concludes my summary.
Thank you, Mr. Garrett. Mr. Chairman, Mr. Garrett is now available for questions from the party and the Commission.
Department of Consumer Affairs.
Yes, Mr. Chairman, thank you. Mr. Garrett, how are you doing today?
Good. How are you doing?
Doing great, thanks. I want to start just by touching on a couple of your criticisms of Mr. Mao. You do not believe his cost of equity recommendations are accurate from a technical standpoint, do you?
That's correct. I do not believe they are accurate.
And I believe at least your primary objections that you mentioned in your summary just now are that he used forecasted growth rates and some other leverage adjustments. Is that right?
Yes. I mean, the forecasted growth rate in this case, I do think it was a little high and ultimately higher than the one that I used, although I do also use a forecasted growth rate. I think primarily, even though I may not have mentioned it in the summary, his estimate for the equity risk premium and the cap-in is unreasonably high. And I do believe the way he applied the Hamada formula for his leverage adjustment is not appropriate.
Have you seen other utility ROE experts use similar adjustments or use similar things to inflate ROE recommendations?
Could you repeat that?
Are those things that Mr. Mao did? Have you seen other utility ROE experts that for utility companies use similar, for lack of a better word, tactics to inflate ROE recommendations?
Yes, in pretty much every case, maybe with the exception of just like one or two, I think they all use tactics to arrive at an inflated equity risk premium input in the CAPM, which is significant. I mean, the CAPM only essentially has 3 inputs, and typically analysts just get their betas from value line. They might calculate their own too, which is fine as long as they're reasonable. But and then the risk-free rate um, is usually based on 30-year Treasury bonds, although many utility ROE witnesses try to use like a forward-looking um, risk-free rate or projected bond yield that is inevitably higher than the current bond yield. But the equity risk premium is almost always inflated, and to me, that's the most important critical component of the CAPM. But with regard to the leverage adjustment, I don't see many, maybe only one other witness try to use that to either inflate the end result or inflate their value line betas or something like that. So Mr. Mao's leverage adjustment, I would say, describe more as unusual.
Okay, thank you. I'm going to try to share my screen momentarily. Bear with me. So what I'm showing, and I hope everyone in the commission room can see it okay. I think I've got it increased about as much as I can. If not, I can read it. This is a footnote, excuse me, this is footnote 19 on page 17 of your direct testimony. And you include a quote from Roger Morin. Who is he?
Roger Morin, well, he's a professor, and he has written a book that on estimating cost of equity and utility rate proceedings. But he is also, as I understand it, he's also testified as an expert witness. But I think it's exclusively or almost exclusively been for utility companies. So I think the book that he wrote that I'm quoting here can be useful in understanding some of the basic concepts, but there's also other aspects of the book that I think are not as objective and more representative of his view as a utility representative.
Okay. And I'll kind of quickly paraphrase it, but he basically in this quote says that if the allowed rate of return is greater than the cost of capital, any excess earnings accrue to the company shareholders, and a wealth transfer occurs from ratepayers to shareholders. Is that fairly accurate?
Yes.
I'll stop sharing that now. So, given its current ROE of 9.93, your market-based COE of 7.1, and your recommendation of 8.9, does PWR currently have excess wealth, in your opinion?
At their current ROE of 9.93%?
Yes.
Yes, I would say that an excess amount of wealth beyond that which is strictly required by Hope and Bluefield, I would say is being transferred to the company from customers based on their current cost of equity estimate under current market conditions.
And you just answered my next question, but that wealth was provided by ratepayers to the shareholders, right?
Yes.
And if the ROE continues to be above the market rate, consumers will continue to provide more wealth than is required to the shareholders, right?
I would say they would be transferring more wealth than what is contemplated under Hope and Bluefield, although that standard is quite broad, I guess you could say.
Thanks. Next, I'm going to walk through your testimony a little bit, and again, you stated some of this in your summary, and I'll apologize to the commission ahead of time. It's a little bit repetitive. I know they've read it, but I think it's important to take a little bit of a closer look. So I'm gonna try not to share my screen too often, but if you don't recall something, then I can pull it up and make sure we all see it. So let me just try to share it for a few minutes. I might be able to increase this one. Mr. Chairman, can you all see this in the hearing room okay?
Yes, sir.
Yes, sir. Okay, great. Mr. Gray, this is the executive summary from your direct testimony. Actually, you know, before I get to this, you include a quote later on in your testimony that defines the cost of capital. And said, since by definition, the cost of capital of a regulated firm represents precisely the expected return that investors could anticipate from other investments while bearing no more or less risk. Does that sound right?
Yes.
Yep. And do you define the cost of equity similarly?
Well, I would suppose so, as being just an element of the cost of capital that is just dealing with equity. But I think you could essentially apply the same type of definition to the cost of equity.
Okay. Thank you. And so again, sorry, I got a little bit ahead of myself, but this is page 7 of your direct testimony, executive summary. And here you state that your objective cost of equity analysis shows that PWR's cost of equity is about 7.1 within a range of 6.3 to 8%, correct?
Yes.
And again, that's your modeling result showed 6.3 to 8.
Right, and specifically 6.3% was the result of the CAP-M, and 8.0% was the result of the DCF.
Okay, thank you. And then right below that, in your professional opinion, it is not appropriate to use an awarded ROE significantly above a regulated utility's cost of equity. That's accurate.
Yes, yes.
Stop sharing now. On page 11 of your testimony, you go on to say that PWR's estimated cost of equity is about 7.1% when using reasonable inputs. Sound all right? Okay.
Yes.
And then I will show this one because it's a little bit longer, just to make sure got it right. So here, I believe you're talking about, looking maybe at the market as a whole, but you say we can estimate a ceiling below which the cost of equity for low risk companies, i.e. beta is less than 1, must be. And thus our estimated ceiling for the cost of equity of low beta stocks is 7.5%. And I just want to make sure, so that was for the overall market or maybe a proxy group. How did you determine the ceiling?
Well, I guess maybe I'm trying to find the best way to explain it, but the CAP-M first has to kind of consider what the required return is on the overall market, and analysts use the S&P 500 pretty often as a proxy for what the overall market is. But that would include all the stocks in the marketplace, of course, very risky stocks, low risk stocks. And if you took all those stocks together, the beta of the market would just be 1. And we don't have the CAP-M formula in front of us, but essentially if you made beta 1, then your cost of equity indication from the CAP-M would be simply adding the risk-free rate to the equity risk premium. And if you did that, what you'd be getting is a cost of equity or required return on the whole market. And if you do that, I would say under current conditions, it's about 7.5%. And I get that from a risk-free rate of about 2%. And these are just using estimates to make it a little bit, just to explain this concept a little more easily. But you take a risk-free rate of 2%, which is about the yield on 30-year treasury bonds. That's a very reasonable source for the risk-free rate. And then the source for the equity risk premium, there's several really reliable sources for that, but the 5.5% is equal to a recent estimate by Duff & Phelps, which is an international corporate advising firm that's very well respected. If they were to estimate an equity risk premium that was very unreasonably high or low, I mean, even their own clients would know better than that. So they want to be accurate on this very important number that the entire financial community cares about. And so their equity risk premium estimate is about 5.5%. We have expert surveys with a couple thousand respondents that are at 5.6%. So again, basically just 5.5. So if we took that 5.5 and added to 2%, you get 7.5%. That is a good, just basic estimate on the required return or cost of equity of the U.S. equity market right now. It's under current market conditions. So all that is to say that now if you're trying to analyze a specific company and its cost of equity, if it is less risky than the market average, which would be shown by a beta of less than 1, you know that its cost of equity is got to be less than 7.5% if you accept those other assumptions as being reasonable. So that's why I call it a ceiling. If you're estimating a low beta or a beta company that's less than 1, a good ceiling in your mind would be 7.5%. And then I guess there's a floor too, which would pretty much be the cost of debt, but we're talking about the ceiling right now. So I think 7.5% is kind of a good ceiling for the cost of equity of any low beta company right now.
And I think your testimony has already established that all utility companies and PWR in particular are a low risk company.
Yes, every once in a while I'll see an electric company. I mean, it's pretty rare with a beta of like at 1 or 1.05. But usually when that's averaged through a proxy group, it's always, every proxy group I've seen of any utility, water, electric, gas, has all been under 1. But more pertinently to this case, every single company in this proxy group that we're using, and I use the same group as Mr. Mowell, they are all decisively less than 1 with an average beta of 0.78 according to Value Line.
Okay. Share my screen one more time, and I believe you may have actually, again, touched on this in your summary. But you state here, this is page 20 of your direct testimony, that you state, in my opinion, when awarded ROEs for utilities are below the market cost of equity, regulators more closely conform to the standards set forth by Hope and Bluefield. Is that correct reading?
Yes.
And you discuss it often, as does our witness, Mr. Rothschild. Hope and Bluefield kind of set the standard for the ROE, right?
Yes.
You continue, I won't share my screen for this unless we need to, but you continue on page 22 of your testimony, and you cite some other, some like Wall Street people to show support for this. Is that accurate?
Oh, which page is this again?
I'm sorry, I can share it very quickly. It's page 22 of your direct testimony. And again, I was just going to point out that they support, here you say, Jack Bogle, the founder of Vanguard and a Wall Street legend, says the total returns for the broader market will be around 7% going forward. You cite another Wall Street legend, Professor Burton, I won't butcher his last name, Malchio maybe, corroborates at 7% in the latest edition of one of his publications. And then below, the Wall Street Journal reports that, actually, I thought this was interesting, that institutions like pension funds are validating the first point by piling on risky investments to try to get to a 7.5% return. That's accurate?
Right. That is accurate. And even though these articles are, I don't know, maybe a few years old, the dynamics are still, we see that they're, to the extent those were predictions, they so far are coming true. I mean, I would say, and it's not really a good indication to look at the actual returns on the market at any given one time, which could be higher or lower than what an expected return is or cost of equity. The actual market's going to fluctuate up and down, but the expected returns on especially the overall market, we don't expect to change drastically from year to year.
And I was going to try to avoid going back and forth sharing, but this is one that I also just really kind of struck me because it's not something I had thought about. This is on that same page, or continuing from that same section, page 23 of your testimony, citing a white paper, but that talks about how excessive ROEs have negative economic impacts, and that they're detrimental to the economy as a whole, not just utility customers. Is that right?
Yes.
And I think it's, if you want to elaborate, please do, but it basically says that when you see these high investments in low risk companies, that's almost drawing away investments from, I think it says inefficient allocation of capital. So it's kind of diverting funds away from more efficient investments. That's something I probably did a bad job of paraphrasing that, but.
No, I would generally agree with how you stated that.
And so continuing walking through your testimony, you go on the next page, you talk about how all these people use the term sticky to describe the slow rate of decline in ROEs. In that section, you note that one of the reasons you know for a slow decline is that so many commissions award ROEs based on other awarded ROEs around the country and failing to adapt to true market conditions. Does that sound right?
Yes, that sounds right. That adjective sticky stuck out to me because it was from two different sources, and maybe one of them had read the other's work. I don't know, but one was from the Utility Fortnightly article, I believe, and the other was from Charles Griffey. But yes, I think, when I was first getting into this area of practice, coming out of my MBA program, I just first noticed that these awarded ROEs are clearly much higher than what any reasonable cost of equity would be. And then just going through over time, just looking at the dynamics, I realized that a lot of, not just regulators, but a lot of witnesses too, like to point to average awarded ROEs around the country. But to the extent any regulators relying on average awarded ROEs, there's a good chance, I would say, that the average of awarded ROEs they're relying on, those ROEs were to a large extent determined by other average awarded ROEs. So you're going to kind of get caught in this echo chamber, which ultimately relates back to, I would say, outdated information. So a lot of utility ROEs are in the 9.x% right now. To me, that would be something reflective of maybe the 90s or late 80s or something like that. So I don't know. I mean, they have been gradually declining as interest rates have declined, but they have not declined as quickly as interest rates, you could say. I mean, they have been declining fast enough, you could say, if the goal was to keep with actual market-based cost of equity. But they are moving in what I would say is the right direction if the goal is to award a fair ROE, but they have been a little bit slow.
Thanks. I appreciate the elaboration on that. And so I won't share my screen again for the moment at least, but you finished this section of your testimony going from page 23, bottom of page 23 into page 24 of your direct. You state, the fact is utility stocks are less risky than the average stock in the market, and thus awarded ROEs should be less than the expected return on the market. Does that sound accurate?
Yes.
Okay. And so I guess, you state all of this, but then due to what you call gradualism, you recommend that the ROE be set at 8.9, which is above the expected return on the market, right?
Yes.
And you base that concept of gradualism on Hope and Bluefield, right?
To some extent. I don't think the word gradualism is used in either Hope or Bluefield, but the Hope and Bluefield standards allow for the end result regarding the authorized ROE to be reasonable, at least in my interpretation of the cases, that they leave it pretty broad. And those cases actually predate the CAP-M and DCF models. So, but even still, that the cases don't say that the authorized ROE has to be exactly equal to the result of a particular model. And so what I'm saying is your last few lines of questioning related to that awarded ROE should be at least less than the market cost of equity. That is kind of the ideal ending point where we want to be. I think the question is, in my mind, what's the best way to get there? How fast we want to get there? What's the most fair way to get there?
And so, like you said, Hope and Bluefield don't mention gradualism, but they do say the returns should be reasonably sufficient. It should be adequate to enable the companies to raise money. Correct? Those terms I think are both used in it, and that they also, from Hope, that it should be commensurate with returns on investments and other enterprises having corresponding risks. Those all sound like the kind of tenets of Hope and Bluefield, right?
Yes.
And then you also say that this is on page 16 of your direct testimony, that your cost of capital models are designed to be in accordance with the foregoing legal standards. Is that right?
Yes.
So if the market-based cost of equity is 7.1 and the stock market cost of equity as a whole is 7.5, would an authorized ROE for PWR in the sevens be reasonably sufficient or adequate to meet the standards in Hope and Bluefield?
Yeah, what I would say is it'd be hard for me, I think, or anyone to make an argument that an ROE in the low sevens, or as you state, would somehow be contradictory to the standards set forth in Hope and Bluefield, because that is reflective of the actual cost of equity in this case for PWR. So again, Hope and Bluefield give us a pretty wide standard, and I think an awarded ROE in the low sevens, it'd be hard to say that somehow violates Hope and Bluefield.
And that's because that return would be commensurate with returns on investments in other enterprises having corresponding risk, right?
Yes, and I think I would even add, even though the Hope and Bluefield cases might not have used this extra adjective, I would say the expected returns would have been a better way for the court to say that. Here I'm saying what they should have said, but because actual returns are very different than expected returns. But the answer to your question is yes.
No, I appreciate that distinction. I think our witness, Mr. Rothschild, would agree with you. So coming back to your recommendation, how did you arrive at 8.9 then instead of say 8.2 or 9.2?
Well, I mean, just out of necessity, with at least in my view of Hope and Bluefield, allowing for the end result to be reasonable, I think that necessitates the use of some judgment. And so the 8.9% is not directly tied to the result of a specific model, but just based on my judgment, considering kind of the totality of the circumstances and what you might say is a dilemma that we face regarding the discrepancy between, let's say, the average awarded ROE and what the actual cost of market-based cost of equity is.
So there was no particular like input to get to 8.9.
That's correct.
So is 8.9 arbitrary then?
Well, I hesitant to describe a recommendation I made as arbitrary, but again, under the circumstances, I would just say resulting more from the use of judgment and having that use of judgment be necessary given the standards set forth by Hope and Bluefield, in addition to the discrepancy we've talked about between authorized ROEs and market-based cost of equity.
So it's subjective, maybe.
It is certainly more subjective than the results of the financial models, which are quite objective.
Okay. So given that, yeah, again, your 6.3 to 8% is objective, and would you say they are accurate from a technical standpoint as well?
Yes, I would say so. Now they are estimates, of course. I mean, the result of any model requiring inputs and assumptions. There is a little bit of judgment that goes into there, but much less so than my 8.9% recommended authorized ROE, which required more judgment. But yes, the results of the financial models, particularly the DCF and CAPM, are based on objective inputs.
Thank you. That's all the questions I have. Appreciate your time.
Thanks.
Attorney Elliott.
Mr. Garrett, can we agree that selecting an ROE is not always a precise exercise?
I think that's fair to say.
And isn't it true that you and I can agree that a utility's good performance or good management is relevant to this commission's discretion in setting a fair ROE. Can we agree to that?
I think that's a factor the commission could consider. I think it should give a factor like that lower weight than what a cost of equity estimate would be, but I think it's something the commission could consider.
But isn't it true that in your surrebuttal testimony, you state that is not to say that good performance is irrelevant? As the South Carolina Supreme Court indicated recently, quote, a utility's business practices and reputation are two of a number of factors the commission may consider in setting an appropriate ROE, end quote. Have I read your testimony correctly?
Well, I think I'd have to see the exact page. I wasn't reading along with you, but that sounds like you read that accurately. Again, it's
Oh, no, no, sir. I don't want to take advantage of you. Would you please turn to your surrebuttal at page 14, line 18?
Okay.
And you take your time.
I'm there.
And again, you tell me if I've read your testimony correctly, please. And I quote, that is not to say that good performance is irrelevant. As the South Carolina Supreme Court indicated recently, quote, a utility's business practices and reputation are two of a number of factors the commission may consider in selecting an appropriate ROE, end quote. Have I read that correctly, sir?
Yes.
All right. And you are among other things, you are a lawyer by education and training, correct?
Yes.
And so it would seem to me to be natural for you to be able to have the ability to find the opinion captioned in re application of Blue Granite Water Company for approval to adjust rate schedules and increase rates. That was an easy thing for you to look up, wasn't it?
Yes, right.
And I would like to ask you if I may read you the full quote from the South Carolina Supreme Court that you only cited a snippet of. And so you tell me if, based on your recollection, or perhaps you have the case there, as I say, you are a lawyer, tell me if your recollection is that the case provides as follows. Quote, finally, the PSC specifically stated it set an ROE at the low end of the proffered ranges in an effort to incentivize Blue Granite to improve its admittedly poor business practices, evidenced by the extensive customer complaints at the PSC hearings. As we previously stated in Utility Services of South Carolina, the PSC is empowered to do so in appropriate circumstances, and there is nothing inherently wrong or punitive in the PSC choosing to follow that path here, citing utility services. Continuing, rather, a utility's business practices and reputation are two of a number of factors the PSC may consider in selecting an appropriate ROE. Does that seem to be your recollection of the full Supreme Court holding that you quoted a snippet of?
I believe you did read that accurately. I have it in front of me. I kind of disagree with your characterization that I cited a snippet implying that I left out something, but I think I cited what I needed to cite it and what I meant to cite under the circumstance. But yeah, you read that accurately.
Well, permit me to help you fill in some blanks, would you please?
Again,
Now,
I'm not
as you
admitting that there's any blanks, but I'm happy to answer your questions about
Excellent. As you understand the case, and you're looking at it, I think, judging from the screen, in that case, the recommended ROEs were 8.65% and 9.45%. Isn't that true?
And where are you seeing that?
I'm reading the paragraph just above the one you quoted.
Okay. Yes, I see that.
All right. And notwithstanding the 8.65% and 9.45% ROE, This commission set an ROE of 7.46%. Isn't that true?
Yes.
And even Mr. Rothschild in that case acknowledged that setting ROE was not a precise exercise, didn't he?
I believe so. I mean, I would agree that it's not a precise exercise.
All right, so we're all on the same page with respect to that. Now, so let me ask you this. You understand from the testimony that Blue Granite, in its proceeding before this commission, admitted that it had poor business practices. You can see that, don't you?
That's my understanding, yes.
All right, now, you are a witness in many proceedings, and this is not your first proceeding before this Public Service Commission, is it?
That's correct.
And you, as a matter of practice, being an expert, make sure that you make a complete investigation of all the facts arising, or all the issues and disputes arising in any given rate case. Isn't that a fair statement?
The ones that are relevant to the scope of my review, what I've been asked to review.
Well, but you admit that a company's good management is one factor to be considered in setting ROEs, correct?
The Supreme Court has stated that the commission could consider that as a factor.
And you are aware, are you not, sir, that in this case, only one witness came forward at the public hearing to testify as to the rate increase. You're aware of that, aren't you, sir?
I'm not exactly aware of that, no.
And but you're aware, are you not, sir, that anticipating what might happen, this commission set 3 public hearings to accommodate all the disgruntled customers that might come forward to complain about this company. You're aware of that, aren't you, sir?
I mean, that's my general understanding of. Was I just talking over somebody?
Yes, sir. If you would just give us a moment to handle an objection. Attorney Huber.
Oh, okay.
Mr. Chairman, I'd object to that as a mischaracterization of the commission's hearing notice in this case. I do not believe it set the notices expecting a large number of.
You can barely be heard.
I'm sorry. Mr. Chairman, I would object to that as a mischaracterization of the hearing notice the commission issued in the case. The commission's hearing notice did not contain the language that Mr. Elliott has described.
Okay.
I've never known a witness to come forward in any of my cases to express happiness with the rate increase. I'll rephrase the question if I may.
Please rephrase. Objection sustained.
You are aware, are you not, that this commission set 3 public hearings to accommodate Palmetto's ratepayers to come and give any opinion they might wish about the rate increase in this case. You're aware of that, are you not?
I'm not exactly sure of the number of hearings, but it's my understanding that the commission gives people the opportunity to do that.
And you understand that after only one witness appeared at the first such public hearing, that the commission canceled the other 2 public hearings. You're aware of that, aren't you, sir?
Not specifically as I sit here, but it wouldn't surprise me to learn that.
And you, as a part of your review of this matter, have read the testimony of Mr. Craig Sorensen, have you not?
Yes.
And you understand that Mr. Sorensen is a 25-year veteran of the water and wastewater business and has relocated to serve as president of this utility in South Carolina. You're aware of that from his testimony, aren't you, sir?
That sounds familiar.
And you're aware that Mr. Sorensen testified that that the company was proactive in its operations and maintenance, such that it changed out its very dangerous gaseous chlorination process to a more stable liquid chlorination process. You're aware of that from his testimony, aren't you?
Yes.
And you would agree with me that such a move demonstrates a proactive management style to prevent a problem before it ever happened. You'd agree with me as to that, wouldn't you, sir?
I suppose that could be a characterization of that, yes.
And so you and I would agree then, sir, that the case that you're testifying in here now is very different from the Blue Granite case in which the commission awarded a 7.46 ROE. You would agree with me that these two cases are very different, wouldn't you, sir?
Well, the companies, I didn't do the cost of capital analysis in the Blue Granite case. So from that standpoint, I'm not sure how the cost of equity results would have been if I had done the analysis in that case along with this case. But they are different companies.
Yes, sir. Thank you. And you understand that in South Carolina, being a lawyer, that rate making is a legislative function. You understand that to be the case, don't you, sir?
I suppose that varies between jurisdictions, and I'm not exactly how that works in South Carolina, but it wouldn't surprise me to learn that.
And you understand that the General Assembly, in its wisdom, has delegated its rate-making authority to this Public Service Commission. You understand that, don't you, sir?
It wouldn't surprise me to learn that.
And you understand that while these commissioners are sitting here in this proceeding as quasi-judicial officers, they are nevertheless exercising legislative authority. You understand that to be the case, don't you, sir?
I'm not specifically aware of that, but it wouldn't surprise me to learn it.
All right, and it shouldn't surprise you to learn that the General Assembly, as a part of its legislative authority and as a part of its delegation of authority to this commission, has determined that the concerns of the using and consuming public with respect to public utility services, regardless of the class of customer, and the preservation of continued investment in and maintenance of utility facilities so as to provide reliable and high-quality utility services is a goal of this commission. It wouldn't surprise you to learn that the General Assembly made that statement of policy as applied to this commission, would it?
It would not surprise me to learn that.
And I refer you to every pre-filed testimony filed by the Office of Regulatory Staff in its 15-year history. Setting rates is not strictly a function of determining which ROE witness one prefers, but rather certainly continued investment and maintenance in and maintenance of utility facilities is an important factor in setting ROE. Isn't that true?
Could you remind me where you're getting that
Do
from?
you have Mr. Hunnell's testimony? Mr. Hunnell, he's an RS witness. I'm not trying to hide anything from you. If you'll look at Mr. Hunnell's direct on page 3, Mr. Hunnell accurately and very kindly sets out this provision. I'll draw your attention to lines 4 through 9.
Okay, I see that.
Do you see that quote?
Yes.
And it references South Carolina Code annotated section 58-4-10.
Yes.
And would you trust that Mr. Hunnell very carefully and completely quoted state law in his testimony?
I don't have any reason to doubt that he did.
Nor I. So accepting that continued investment in and maintenance of utility facilities so as to provide reliable and high-quality utility services is a factor to be taken up here, I'd like to refer you back to the Blue Granite decision. Do you still have that on your screen or handy?
I do.
And so a factor in setting ROEs might be the overall rate increases allowed to other similarly sized utilities in the same general time frame. That would be a factor, wouldn't it?
Now, was that mentioned in this case, or you're just asking if it could be a factor?
Well, I'll ask you if it could be a factor.
I think the commission can consider a variety of relevant information. I just think that with something like that, the average awarded ROEs or one from another jurisdiction should be given much, much, much less weight than the actual cost of equity estimate.
Well, and I accept your testimony coming from an expert ROE witness. So let's consider a few other matters, as you say, is reasonable and appropriate under these circumstances. You recommend an ROE of 8.9%, correct?
Yes.
And notwithstanding the fact that these models that you have prepared and testified about might have a lower number, you give the very practical reason of trying to avoid trying to bring the ROE down for this company sort of in a step-by-step basis. Isn't that a fair description?
Yes, that's related to the gradualism concept discussed in my testimony.
All right, and so that's a factor we can agree that this commission might take into consideration when it sets the ROE in this case, correct?
Yes.
Now, as a part of your work on behalf of the Office of Regulatory Staff, and you've testified for them at least twice, correct? Here and in the Dominion rate case?
Yes.
You, as a matter of practice, review the ROEs awarded to other similarly sized utilities in this jurisdiction preceding the case at hand. Isn't that true?
It's something I do look at, but not to make the point that we should be looking to those to set an authorized ROE. I use that in one of my analyses to kind of show a trend of where ROEs are going and to make the ultimate point that actual utility cost of equity is lower than authorized ROEs.
But it's fair to say that your research and investigation, your very detailed research and investigation into this case, would reveal that in the last 10 years, this commission has not set an ROE below 9%, except in the Blue Granite case where it set an ROE at 7.46%. Your investigation showed that, didn't it?
I believe that's correct.
And accepting the fact that you're an expert in ROE, Mr. Sorensen is similarly skilled in the management of his wastewater company. Wouldn't you agree?
I'm not doubting Mr. Sorensen's skill as a manager.
And as a manager of a wastewater company, it falls to him, among other things, to gain access to capital, borrow money, as the average person might say. Isn't that true?
Yes.
And Palmetto Wastewater is competing in South Carolina in this jurisdiction for capital with other companies of similar size. Isn't that true?
I suppose it's fair to say that. I hear that a lot, competing for capital, but you know, as it really plays out in the real world, I'm not aware of a situation where a utility has not been able to raise capital, and such that they were so overwhelmed by the competition, when they went to issue shares or, lend money, they weren't able to raise any capital. But just generally speaking, I would generally agree with you on that. I suppose they're competing for capital.
Well, and I appreciate that, but you're an expert in ROE. You're not an expert in wastewater management, are you, sir?
That's correct.
Now, you heard also Mr. Sorensen testify that not only was he competing with utilities in this state, but he was also competing with utilities, affiliated utilities, for capital. You heard him testify that, didn't you?
Yes.
And you will recall from his testimony that he prepared a chart wherein he showed that the Palmetto affiliates in Texas, Florida, Oregon, other utilities in South Carolina and California all had ROEs in excess of 9%. Isn't that true?
Yes, I believe so. I'm pulling up the chart now. If you're referring to page 4 of his rebuttal testimony, is that right?
I'm looking at the chart, but it starts with the Monarch Utilities case at the top.
Yes, I see that chart.
All right. So a factor, as far as Mr. Sorensen is concerned, who is in the business of managing wastewater utilities, is having an ROE sufficient to attract capital and compete with other utilities investments. Isn't that true?
I take it that is something he believes is important. Yes.
And you would agree that it's proved him well in that he has a very well managed and operated utility here, doesn't he?
I don't have any reason to say that that management is operating the utility imprudently.
Well, I think the proof's in the pudding, isn't it? Only one sweet little old lady came in and complained about a $5 rate increase. Isn't that evidence of the management?
I didn't see her in person, so I can't attest to her sweetness or her age, but I don't have any reason to doubt the management performance.
Well, I don't think she'd object to my characterization. Now, that brings me back to the Blue Granite case. And the difficulty that I have with we'll start with the proposed ROE of the Department of Consumer Affairs. Do you understand the Consumer Affairs recommended ROE to be 7.31%?
Yes, that's my understanding.
Now, we've discussed how when this commission several years ago, in the words of the Supreme Court, incentivized Blue Granite to improve its admittedly poor management, it awarded Blue Granite a 7.46 ROE, correct?
Yes, I think there were a variety of reasons, I'm sure, that went into that, but 7.46 was the final awarded ROE.
Well, and you don't dispute that the Supreme Court used the term incentivized, do you?
Oh, I wouldn't be surprised.
Well,
I wouldn't be surprised to learn that. But
it's part of the overall quote that you lifted from the case in your testimony. I'd welcome you to look it up if you have any questions, because I don't want you to think that I'm trying to pull anything over on you.
I don't believe that. I just want to make sure my testimony is accurate, and I do see that incentives discussed there.
All right, and so you and I can agree that that if a 7.46 ROE is to incentivize improvement for admittedly poor services, a 7.31% ROE would incentivize less reasonable management of a wastewater company, wouldn't it?
I don't agree with that.
Well, Mr. Garrett, if you're in the doghouse in South Carolina and you get a 7.46 ROE, and you're the best managed company in South Carolina and you get a 7.31 ROE, what does that say to the equity market, sir?
Well, I would say, actually, Mr. Rothschild's 7.31% cost of equity estimate is actually a little higher than mine. It's 7.1%, but I would describe it as accurate. The difference between our positions is he's taking a less gradual approach and getting to what I would describe as where we need to be, with our authorized ROEs being closer to cost of equity. And I would have that opinion even if the Blue Granite case didn't even exist.
Well, Mr. Garrett, forgive me, but I would characterize your position as being a real life position here in this case and not.
Mr. Chairman, I don't object to counsel testifying here if he has a question, but how Mr. Elliott characterizes something I don't think is a question.
Mr. Chairman, I'm on cross-examination, and it's Mr. Huber's
He's still
witness.
testifying.
I'm gonna allow it, but I will say, Attorney Elliott, you can have a second career in many different things if you would just reel it in a little bit.
Yes, sir.
All right.
Thank you. Now, as we've discussed, there are many factors that may be brought to bear in setting an ROE. Is that true?
Yes, I think that's fair to say.
Now, you testified in the most recent Dominion rate case on behalf of the RS, did you not?
Yes.
And as I recall, you were a depreciation witness in that case, not an ROE witness. Am I correct?
That's correct.
But you would understand that in that case, the commission approved a 9.5 ROE for Dominion. You know that, don't you, sir?
Yes, yes, that sounds right.
But I'd like to dig a little deeper into that case, if I may, just to make your point that that there are multiple factors that may go into setting an ROE, if I may. And so, you know, as I understand it, as a part of your study of the of Dominion's depreciation schedules, you were compelled to familiarize yourself with the company's assets, were you not?
To the extent it related to my depreciation analysis.
And indulge me. You were compelled by duty, really, to investigate assets such as steam production, nuclear production, hydraulic production, and other production, correct?
Yes.
And in making a thorough analysis of the various areas of production, such as nuclear production, you would have learned that Dominion was recovering $2.7 billion in nuclear costs resulting from the failed nuclear construction in Jenkinsville. You became aware of that, didn't you, sir?
Mr. Chairman, I'd like to object here. We're getting into assets in another case completely different than the one before the commission. I don't understand the relevance here.
I'll tie it up in about 2 minutes, Mr. Chairman.
All right, but if you would put a response to the objection on the record.
Yes, sir. The question to the witness is deals with the number of factors that go into setting ROE. And I believe this witness will have evidence of the fact that in the case of Dominion, the Public Service Commission, in dockets by order number 2018-804, allowed Dominion to recover $2.7 billion in nuclear costs which were not used and useful, and awarded the company a 9.9% ROE on those costs that were not used and useful. And so the point I'm trying to stress here is that there are many factors that are within your discretion in setting ROEs, and you are not limited to the testimony of these experts, and they're experts. I don't dispute that. So that's where I'm going, and it won't take me long.
Objection overruled.
So, Mr. Garrett, my questions to you concerning this are simple. You are aware, by virtue of your detailed investigation of into the assets of Dominion in preparation for your testimony in the most recent docket, that the company was recovering in excess of $2 billion by the time you did your report in what's called NND development. These are the nuclear costs that of the abandoned plants. You became aware of that just by virtue of the fact that you made a thorough analysis, correct?
I think some of those issues would fall outside of the depreciation analysis I did in that case, and I don't have those numbers in front of me, but I wouldn't be surprised to either learn or refresh my memory about that.
And you were aware that just by virtue of your study, it's not part of your testimony, and I don't suggest it, but you were aware as a part of your study, and it's a matter of record that the company was allowed to earn 9.9% on those useless parts.
Again, I don't have the number right in front of me, but wouldn't be surprised to learn that. Well,
And if you learned that, or it was confirmed for you, it would be your testimony, and you would agree with me that that setting a 9.9% ROE on these nuclear costs that were not used and useful was well within this commission's discretion. You would agree with me there that the commission would have acted within its discretion?
I object here, Mr. Chairman. The witness already said he's not familiar with this, and that Mr. Elliott's asking him to speculate on this. I think the questioning is improper.
Oh, Mr. Chairman, he's an expert on ROE, and I'm entitled to cross-examine him on his opinion and the depth and breadth of his opinion. I'm simply asking, the question was, would he agree with me that that this commission acted within its discretion in setting a 9.9% ROE on costs that were not used and useful?
Right, I understand that. The only issue is he seems not to really know the answer to your questions. He's just sort of agreeing with you. So, sir, if you can answer the question, answer it. But if you can't, don't. Mr. Elliott is right. He is an expert. So if he can answer the question based on his expertise and his study, he should be able to. Or Mr. Elliott is at least entitled to ask the question. Overruled.
All right, Mr. Garrett. We're near the end. Would you agree the commission acted within its discretion?
I don't think I'd ever suggest a commission acted outside of their discretion when awarding, a particular ROE.
Yeah, I would have thought that would have been your answer. Mr. Chairman, may I ask the commission to take judicial notice of order number 2018-804? This is the order that disposed of several dockets involving the SCE&G, then later Dominion nuclear litigation.
Notice taken.
Indulge me, all right, Mr. Garrett, as far as you know, the company has not sought to recover costs that were not used and useful, correct?
I'm not aware that they've made any request for that.
And as far as you know, the company is prudently managed, correct?
As far as I know.
And as far as you know, the commission has the authority and indeed the duty to incentivize continued investment in this utility so that it may maintain its very high level of services. You agree with that, don't you, sir?
I don't necessarily disagree with that. I think the commission's bound by all the rules and standards that it is, and I'm not sure you need me to confirm or deny any of those.
Mr. Chairman, I don't have any further questions of this witness. While I have the floor, I was going to ask you to take judicial notice of an additional order, but I don't have it in front of me, but I'll ask it later in the proceedings if I may. But thank you so much for indulging me, Mr. Chairman.
All right, we're in recess for 10 minutes. Good afternoon, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina. We're here in docket number 2021-153S. Present in the hearing room are Commissioners Williams and Belzer. Joining us virtually are Commissioners Powers, Caston, Curley, Williams, and Thomas. All right, we're finished with cross-examination of Mr. Garrett. Is there any redirect?
Mr. Chairman, I'm not sure we did, I'm not sure we did commissioner questions.
Right, you're absolutely right. Commissioner questions for Mr. Garrett.
Mr. Chairman, this is Commissioner Thomas.
Commissioner Thomas, you have the floor, sir.
Thank you. Mr. Garrett, appreciate you being here this afternoon. I guess I'm just trying to kind of figure out where we are at this point. I mean, obviously we're in the position, we have to make the decision as to what is fair, just, and reasonable to all parties, given where we are today. And we've heard testimony from 3 experts on rate of return, and you know, there's a lot of differences of opinion, but we're getting a lot of good information to work from. So, you know, just looking back, your original recommendation, you had a range of 6.3% to 8%, but you recommended an 8.9%. And we've had a settlement or stipulation, and you originally, I think, had a 50-50 capital structure. The settlement was 45% debt, 55% equity, so that's a little bit less risky than the 50-50 that you started out with. And just given the way things are going and the trends and the financial markets and all of that, I guess you use the term the totality of the circumstances and in using your judgment. Do you still think that the 8.9% is the right number, or could that be adjusted up or down?
Well, it's hard for me to say that any one number is right versus wrong when it comes to setting an ROE or even estimating cost of equity. And I did want to make one distinction, that the range from 6.3 to 8% is the cost of equity range, which is necessarily a different concept, although related concept to the awarded ROE. But to answer your ultimate question, I think there's plenty of evidence on the record in my testimony and Mr. Rothschild's testimony that would provide support for an authorized ROE being lower than 8.9%, but it's certainly a range of reasonableness. And I think that the ultimate goal is to get, as I understand it, to get to the most fair and most reasonable result, even if some results on either side could also be considered fair, a little up or down. But in this case, I think it'd be hard to make an argument for going higher than 8.9% based on just the evidence in the record.
Okay. Thank you. I appreciate that. That's all I have.
Thank you.
Chairman Williams.
Commissioner Caston.
Good afternoon, Mr. Garrett.
Good afternoon.
I guess along those lines, relative to the gradualism, I understand you're saying that the market-based range was 6.3 to 8. But this gradualism, it said it was, you know, subjective, but also based on, I guess, experience or whatever. Would that, like this gradualism, would that not be best handled in a rate case rather than picking a subjective number or the commission picking?
Well, as I understand it, I think it's gradualism is a rate-making concept that could be applied to all kinds of different issues in the case, whether it's more from a customer's perspective, although that I think the vast majority of the time it is kind of applied to customers' benefit because rates are going up, and you don't want them to go up too high in any one case and amount to rate shock for customers. But I'm essentially taking that same concept and kind of applying it to the shareholder's perspective in a way that it could be considered fair to not make drastic adjustments in the ROE. I think also Mr. Rothschild makes somewhat of a similar point in his recommendation because the midpoint in his range was 6.9%, which I think is a very reasonable cost of equity estimate. But he's ultimately recommending 6.31%. So his approach is much less gradual than mine, but it's still kind of the same concept. And again, as I stated to the previous question, there is plenty of evidence on the record to support the idea that the authorized ROE could be lower than 8.9% and therefore less gradual than the 8.9% that I've recommended.
Well, I'm trying to reconcile, reading in your direct testimony, in my professional opinion, it is not appropriate to use an awarded ROE significantly above a regulated utilities cost of equity. And I don't know what significantly is. Is that 0.5? Is that 1? Is that, I mean, I guess I just ran some quick numbers and I may have done it wrong. But if you had selected the higher, the 8%, rather than 8.9, and used it, I think wherever I did those calculations, I think the rate of return, I think there'd be like a 0.5% difference, a 0.5% difference in the rate of return versus 8.9%. So why couldn't it have been 8, 8.3, 8.5? I mean, why did you select 8.9?
I was kind of just double checking the math on the fly, and I think you did state that correctly. In my discussions with Mr. Hall, I have to, I mean, admittedly, 8.9% is, there is some judgment that goes into that. When you're trying to determine something that's reasonable, I guess in an ideal world, not that I'm all that idealistic, if awarded ROEs were in that 6.5% to 7.5% range, then I think what you would probably find is witnesses like myself, Mr. Rothschild, I think maybe a lot of others at that point, if that was more of the status quo, you would have witnesses just recommending their cost of equity results, or maybe a little bit higher with some judgment based on the fact that, or based on the idea that, I don't know, you'd want to have the utility have a little bit more of a cushion, or you could go to the higher end of the range of a cost of equity estimate. There still would be judgment involved in that process. But let's say in an ideal scenario, with awarded ROEs being closer to cost of equity, witnesses wouldn't be faced with the dilemma that I'm faced with, or I would describe in that way, to where I think there is the right, so to speak, answer is that low 7% range, at least in this case. Of course, the analysis would have to be done on a case-by-case basis. But that's where we need to go. I guess there's just a difference of opinions of how fast we get there.
All right, along the lines, because I'm trying to think in terms of, is it a fair statement, or am I understanding it correctly, in that the more stable, reliable, or whatever the company, the less risk, correct?
Yes, the more you're saying, the more stable the company is, the less risky it is.
Yes.
Yes, that's correct.
So would you normally expect higher returns on equity or lower returns on equity for a, more stable railroad?
Well, just generally speaking, we measure market risk when particularly in the CAPM. So we have an objective measure called beta to where we can actually confirm what I think is pretty well known, that utilities are low risk companies. We all just kind of know that, but we also have an objective mathematical measure to look at to prove that more or less, which is the beta term. And yes, risk does correspond with reward in the market, or in this case, the cost of equity, and then in turn, what should be the awarded ROE. So yes, I would say the less risky a company is, the lower its cost of equity estimate will be, and then the authorized ROE should, or at least eventually should, be more commensurate with that low risk.
And Attorney Elliott, in his question, when he was, and I'm not saying this is what he was saying, but it sounded like a performance, maybe a performance-based measure, or I wouldn't say performance-based measure, but all right, why should the utility, let me back up. I don't want to phrase it for him, but okay, if the utility is well-run and doing well, it seems like he was asking, you are implying that as a performance reward, they should have a greater return on equity. So the two seem to be in conflict if you're looking at performance-based linked to ROE. But what is your opinion? I'm not sure.
Yeah, I think I understand your question. I think for Mr. Elliott, he had a line of questioning that was related to the blue granite opinion, and I guess seeing to the extent I agreed or disagreed with that, but I think it's a factor the commission can consider performance, but it should be extremely low compared to cost of equity. I mean, the awarded return should be based on cost of equity. Something like managerial performance, I mean, I'm just partly saying this, I don't want to disagree with the Supreme Court's opinion. If they say that it's a factor the commission can consider, I imagine the commission can consider a variety of different factors, but the most important factor it should consider is cost of equity. I think that's clear. And I think there's some other things to be said to it too, like a company performing prudently, I would think is more just the status quo. I don't know why it should get some kind of extra award, and that award coming from ratepayers' pockets, by the way. I don't see exactly how that translates. And another thing I would add to that, when it comes to cost of equity analysis, managerial performance is zero consideration. And the best evidence of that is just to look at the Nobel Prize winning CAPM formula that has different inputs you consider. There's no input for like a managerial performance or something like that.
But is it not in the customer's best interest for a company to be well-ran, hopefully to the point of where they're spending less and keeping costs down? Would that not make sense? Would that not be to a customer's advantage?
I think in general, yeah, cost should be minimized to their lowest reasonable level, and that includes probably the most important cost to the company, which is the cost of capital, which is heavily driven by the return on equity. I mean, in a competitive environment, Walmart, Amazon, any company in that environment, they have a natural economic and financial incentive to minimize capital costs, because that, all else held constant, maximizes the value for their firm. But in this context, utilities don't have that same incentive. It's kind of reversed. They would like to have as high of an ROE as they can, and that's all, that's expected. So I think, again, minimizing costs to their lowest reasonable level. I mean, even as a customer advocate, I'm not coming in and recommending a 2% or 3% ROE, because that would be so unreasonably low. That'd be below the cost of debt. That's not fair. A fair result is one that would have the awarded ROE be reflective of market-based cost of equity, and you have two independent witnesses who did not, not communicated with Mr. Rothschild about any of this, by the way, that are both around, very, very close to the low sevens, 7.1% versus 7.3%. And actually, the midpoint of his is 6.9%. So if you took the average of his models at 6.9, the average of mine at 7.1, you're about at 7%. And I think that's a very reasonable estimate for the cost of equity. The question is how fast to get there.
Yeah, I had those numbers calculated somewhere too, but I can't find them. But, thank you very much, Mr. Garrett. I have no more questions. Thank you.
Thank you.
Fellow commissioners, questions for Mr. Garrett? Redirect.
No redirect, Mr. Chairman.
All right. I didn't think we were going to make it, but we did. Are there any questions before we adjourn? Questions about proposed orders? Procedural matters? Yes, you may, sir. Go right ahead.
Sorry, I don't mean to interrupt, Mr. Elliott. Can Mr. Garrett be excused?
Oh, yes, sir. Sorry about that, Mr. Garrett. Mr. Garrett, you may step down. You are excused.
Thank you.
You're welcome.
Mr. Chairman, I would rise simply to ask the commission to take judicial notice of its order number 2021-570 dated August 16, 2021.
Attorney Elliott, I hate to ask you to repeat all of that, but I need you to get to a microphone.
Apologize. Mr. Chairman, I rise simply to ask the commission to take judicial notice of order number 2021-570 dated August 16, 2021. It's the final order in the Dominion rate case, wherein the commission set an ROE at 9.5%. I simply ask the commission to take judicial notice.
Judicial notice taken, sir. Attorney Huber.
Nothing else from ORS.
All right. If the parties have any questions, please reach out to the lawyer on this case, Attorney David Butler. If there's nothing else, we are adjourned.